A loved one passed away, and I'm trying to figure out whether I need to go through probate. Hi, I'm Darren Findling of the Probate Pro, and we get this question asked all the time: what is probate? And the reason it's confusing is that the word probate and probation sound alike, but in fact, they have nothing in common. The word probate itself is a Latin derivative from the word probo or probare, which means to try, test, examine, and prove. And the idea in the old days was that the probate court would be the forum to try and test and prove the validity of a will. So what is probate in Michigan? Well, in Michigan, probate is the legal process that may be required, is usually required after somebody dies. We're going to examine when probate is needed and when probate is not needed. It provides for the orderly resolution of the person's financial affairs. That may include assets, things that they owned, and debt, things that they owed to. The probate process addresses the situation whether the person had a will or no will. Who are the heirs? It provides for the notification to creditors, the resolution of any creditor claims, the orderly gathering and marshaling of that person's financial assets, and of course, their eventual distribution. So let's examine this and how probate works. At the Probate Pro, we assist people through the probate process. So what I'm going to do in this video is help you at home understand when probate is necessary, when it's not, what alternatives there are to probate, and if you're involved in probate, what that process looks like. Obviously, the first question we have to answer is, do I even need to go through probate? And the way we answer that question is to have a deep understanding of the decedent's assets, understanding how each asset was titled. And sometimes that's really easy to do. You could simply look at a deed and identify who the owner is. A car title to look and identify who the owner is. Sometimes it's not so easy, like a bank account, because they may not give you access to that information. But understanding if the decedent owned assets in their individual name, with a will or without a will generally require you to go through the probate process. One of the ways we can determine whether you go through probate is to first understand what assets and what things don't go through probate. And let's examine that. If the decedent died owning a small account or a small asset, generally you can avoid the probate process. There are a few very short form processes that exist to allow you to get that particular small asset from the decedent's name into the family member's name. For example, if the decedent had no other assets and just an automobile, the Secretary of State has a process to convey the asset from the decedent to the family member. Another example, a bank account with a small amount of money in it. There are two ways to get that asset from the bank account into the family member's name. One is a form called the decedent's successor in interest affidavit. This form is a state court administered form, and if you'd like it, you can contact our office. We'll provide it to you. The other way is through a small probate estate administration process called a petition in order for assignment. Both of these avoid the extensive probate process. This is really helpful because often people die with minimal assets in their name. And there's a need to, for example, to pay a funeral bill or other obligations after somebody has died. If somebody dies with just a small bank account or a small asset value, generally we can avoid the probate process. In addition, if somebody has no assets and just debt, there's no need to go through probate. Generally, there would be no need to commence the probate estate if all that individual had was debt. because debt itself is uncollectible if the decedent owned no assets. Now, there are times where probate estates are opened and there is a right to open an estate by a creditor. But if there's nothing to collect from, if there are no assets, there's really no recovery ability. So generally, estates, when people have died and there are no assets and there's just debt, generally there's no need to commence a probate estate. What happens if the decedent only held a jointly held asset? For example, the decedent and partner owned a house together as joint tenants, and that's all they owned. Would there be a need to go through probate? And the answer is no. By operation of law, when the decedent dies, the survivor benefit goes to the partner. The same holds true in bank accounts. Now, if there are other reasons to go through probate and there are jointly held assets, the same rule applies. But rather than avoiding probate altogether, that jointly held asset is not included in the probate inventory. It's not part of the probate estate. The same holds true when an asset is held by husband and wife or a spouse. For example, property is owned by a married couple and the only asset is that house that's owned that way, and one dies. Again, by operation of law, the survivor takes that property as the surviving spouse. The same would hold true with a bank account. And in the previous example with a jointly held asset, the same holds true if there are other probatable assets in a probate estate, but there's also a spousally held asset. In that case, that asset would be excluded from probate and the other probate assets would be reflected on the inventory. Another asset that does not go through probate are assets with a named beneficiary. The most common example would be a life insurance policy. The decedent was the owner of the policy was measured on that decedent's life, and there's a named beneficiary. The named beneficiary receives that asset outside of probate by simply providing the requisite claim form and death certificate to the insurance company. It is not reflected in a probate estate, and there is no need to open a probate estate. The only time a probate estate would be needed is if for some reason either the named beneficiaries have all died and there are no named beneficiary, or the beneficiary designation was the decedent himself. This is not particularly common, in which the person who created or opened the life insurance policy actually names themselves, but it does happen periodically. So a named beneficiary account, whether it's life insurance, a bank account, a 401k, is not a probatable asset as long as there is a named beneficiary. So what happens when you go through probate? What does this mean? Well, probate, as we discussed, is the orderly disposition or resolution of that person's financial affairs. In this video, there's a description of a basic timeline from the beginning of commencing the probate estate all the way through to its closing of the probate estate at the probate court. Now, you open a probate estate by filing either a petition or an application in the probate court. And you choose the probate court based on the residency or domicile of the decedent. If the decedent died outside of the state but owned an asset in the state, you can commence it in that state. You file that document with the probate court, and ultimately you go through this process by receiving a letter of authority, which gives you the powers under Michigan law to administer the financial affairs of the person that died. You publish in the legal news for any unknown creditors. You give direct notice to known creditors, as well as notice under the law to the friend of the court, to the IRS, and to all of the interested parties within the estate. There is a gathering of the assets, an identification of an inventory that's presented or filed with the probate court, And then ultimately there's a resolution of the debts based on a priority statute that Michigan law provides. It provides for the order of payment. So for example, if there are insufficient assets to pay the attorney bill, the fiduciary fees, the exemptions and allowances, the funeral and burial, and all of the family members that are entitled under either the will or intestacy, Michigan law dictates how you decide how those payments are made. And eventually the file gets closed out at the probate court when everything is concluded. Now, I'm oversimplifying this entire probate process. The key advice I could give you is work with a competent and skilled, experienced probate practitioner, somebody that you can trust through this entire process. At the Probate Pro, we work with thousands of probate estates at any given time, assisting people through this probate process. It is a process that is not simple. Sometimes it's easier than others, but it is understanding the nuances of probate law that can help ensure that you perform your responsibilities under the law, you maximize the value that you receive, and you perform all of your duties and responsibilities under Michigan law. If you've got questions about probate-related issues, feel free to contact us at the Probate Pro. Our phone number below, 833-PROBATE, is easy to remember, or you can visit us at theprobatepro.com. We hope that this video has been helpful at explaining what is probate. But if you have questions, give us a call. We're happy to help.